Hello, this is John Milburn for Laws 13010. This is week 3 in term 1, 2017. And what you're watching is a re-record of last night's session, which failed for technical reasons, i.e. me. My apologies. Tonight we're talking about evidence in the context of the first assessment piece. Let's have a look at that first assessment piece, which we did touch on last week. To do that, I'll share the screen. You should see a Word document, and that Word document is the first assessment. This is the oral evidence witness examination assignment, and your task is to present on an audiovisual session with me, acting the part of either the prosecutor or defence counsel. You have 30 minutes as a group of 2 to complete the assessment. That means 15 minutes each. And you are assessed individually. By that I mean that even though you're in a group of 2, I'll be assessing the work of both individuals separately. It's not in any meaningful way a group assignment, but it does have some hallmarks of a group assignment in that I think you should take the opportunity to discuss the issues and to undertake a number of trial runs with the person that you've partnered up with to join me in the session. The more prepared you are for this session, invariably the better you will do. By way of preparedness, what I mean is that you should be writing your questions in advance and have them in a format that you can readily access so that there's a fluency about your work. In some ways, there are some acting skills associated with being a person involved in court proceedings. Some of the things that you need to consider are the clarity of your voice, the fluency of the proceedings, and the logical way in which you present the material. To have a script is, I think, the best way to go. But a word of warning, be prepared to alter the script, and by script I mean series of questions, as things progress. To do that, you need to be listening very carefully, because playing the role of Xavier Kelly, I may toss in a few little things that could throw you from your script. Don't worry, it won't be too hard. And I know that this could be a daunting exercise, so I'm not going to mark you very harshly for this. This is really meant to be something that is worth 30% sure, but also fun. So prepare your script, give me at least 10 to 20 questions each, submit those via Moodle, put them in a Word document and upload them in the normal way that you would for any assessment. I'll have a look at those questions and I'll understand what you're looking to do as part of your examination, if you're the prosecutor, or cross-examination, if you're the defence counsel. In all likelihood, you'll need more than that number of questions. The reason I say you'll need more than that number of questions is that when you're leading the evidence as the prosecutor, as we discussed last week, keep your questions focused and quite short. And be careful not to layer the questions. Layering the question means adding in more than one concept in the question. Take a simple example. You're the prosecutor, you're asking a witness about an event where the witness was driving. The first thing that you don't do is lead. So you don't ask a leading question, which is, were you driving the red car on Saturday? The second thing that you don't do is layer the question by incorporating 2 concepts or facts. So asking about driving a red car is one thing. Asking about driving on Saturday is another thing. So don't ask both, or don't allude to both matters in the one question. Separate them. So short questions, open questions that deal with one concept only. When you're defence counsel, the same rule applies, but your questions are, you're perfectly entitled to ask closed questions, and indeed, I think you should ask closed questions. So what you're doing is putting various propositions to the witness, and where you can, have them answer with a yes or no. Allowing the witness to elaborate when you're cross-examining can be dangerous. The witness may come up with some new information that hurts your client, hurts your case, rather than helps it. Okay, so that's the basic task. Have fun with it, enjoy the process, and in order to prepare for it, you need to undertake reading of chapters 1 through to 4 of Field. You probably need to go further, in fact. And by that I mean, it would be very useful to have a look at chapter 6, which is some reading in advance, because that deals specifically with oral evidence, examination in chief, and cross-examination. And skim through some of the later chapters without necessarily reading them in detail. Have a look at some of those chapters that deal with issues to do with exclusion of evidence, and in particular, admissibility, hearsay, etc. So those chapters in the Field text that you should skim through relate to opinion evidence, which is chapter 11, chapter 10, hearsay evidence, chapter 9, hearsay at common law, and chapter 12, improperly obtained evidence. I know that's a great chunk of the book that I'm asking you to read now, but remember your speed reading skills. Certainly in Introduction to Law, I speak about that, where you have an opportunity to select the main points. Do that now before you do the assessment. Okay, so what will happen when we do this assessment? We'll be online. It'll be a half-hour session. I'll record the session. And the reason I record the session, although I keep it on a private setting, is if there's an issue to do with remarking. I'll play the part of Xavier Kelly. It may be, and I expect that at various times, I'll need to morph out of that role into the role of, if you like, pretend judge. If you feel the need to object to a question or give an objection pending the answer of the witness, then feel free to do so. But don't overdo it. This is not an exercise where I'm looking to mark people extensively in relation to objections. And indeed, I may not mark people at all. But if someone does make a very valid objection, which is entirely appropriate, then I will reward you if I can for doing that. But it'll be quick. So let me give you an example of where you might object in this situation. Your defence counsel, prosecutor asks a clearly leading question. As defence counsel, just simply say object, and I will, without announcing it, probably just morph straight into the role of judge and say sustained, overruled, and then go back into character of Xavier Kelly. We can discuss the issue of the objection at greater length. But I guess what I'm saying is try not to object, but if it's an issue that is clearly obvious, then feel free to object. I hope that makes sense. When you're going through the process of examining or cross-examining Xavier, you need to identify the main issues. So what is really important in this case? If you're the prosecutor, you need to firstly look at the charge. You'll see that it's robbery. You'll see the indictment, which is, if you like, the particulars of the charge, which would be on an indictment. And you need to ask yourself, which of those issues can I extract from the evidence of Xavier Kelly that will help to support the charge? Now, prosecutors are model litigants, so they're not doing everything they can to secure a conviction. What they are trying to do is present the evidence fairly, but the evidence must be presented in the context of the charge which has been proffered against the defendants. So if you're asking questions that extract information that is not relevant to the charge, you run the risk that I may mark you down. You only have 15 minutes. That time will go extremely quickly. It'll be over in the blink of an eye. So when you're preparing your questions, ask yourself, is this a question that helps to extract material in relation to facts relevant to the charge? Now, it's all very artificial because you don't have the opportunity to speak to Xavier Kelly before Xavier's in the witness box. That's unheard of. And also, you don't have the benefit of the other evidence that no doubt would be presented, other witness statements, fingerprint analysis, CCTV, none of that. So I appreciate this is in many, many ways very artificial, but you get the idea that what we want you to do, if you like, the aim of evidence, is to use relevant and admissible evidence to prove a material fact. Start with those words, material fact, and ask yourself, as you go through the statement, what is a material fact? Let's take a quick example. Paragraph 2 says, I was born on 19 October 1951. I'm a truck driver, unemployed, receive a pension, former soldier. You could easily spend 15 minutes just on that section, subsection 2, paragraph 2 of the statement by going through that background. And in a trial, you probably would as a prosecutor, but given the constraint that you've only got 15 minutes, you wouldn't want to leave the examination in chief at statement 2 because in itself, there's nothing in statement 2 that proves anything. So make sure your priority in asking your questions are those questions that relate to the material facts relevant to the charge. Now, the same thing applies in defence, that what you're looking to do is extract evidence that might cast doubt in relation to your client's guilt. I'll just stop there. What do we mean by your client in this context? There are two defendants, Scott Drysdale and Simon Bancroft. They've both been charged with robbery. My preference is that you select one of them and announce in your questioning that you upload in Moodle and at the start of the trial whether you're acting for Drysdale or Bancroft. So when you're questioning Xavier Kelly, what you're really looking to do is cast doubt in relation to the evidence presented to the court involving a material fact. Okay, let's say you have information or you have a suspicion that Xavier Kelly is not as unemployed as he makes out. Maybe he has a side job and maybe he's doing something to mislead Centrelink. If you ask questions in cross-examination about that, you run the risk that I will be concerned that firstly you're fishing, meaning you're looking for things that don't necessarily exist on the material that you've got. And secondly, you're asking questions that are not relevant to the case. So try in cross-examination to keep your questions relevant to the case. And what you're trying to do is create doubt in relation to material facts that are presented in this case. Ask closed questions, which generally mean the witness will be answering yes or no. People might say, what do you think is more difficult, examination in chief or cross-examination? Well, they're both pretty difficult, but probably examination in chief is slightly more difficult, I think. But anyway, I guess I've been defence all the time, so maybe I'm just used to it. All right, let's just have a look at the further statement. That's the end of the assessment. Xavier Kelly hears a loud noise like a gunshot. There's a whole lot of things that you could ask in relation to that. There's no right or wrong answer here. I don't have a rubric which goes beyond the rubric which is contained in the material that you've got. So just be careful to consider the assessment in the context of what I've said is the rubric and how I allocate the marks, which is at the bottom of the front page of the assessment. Okay. While I'm sharing the screen, I'm just going to take you to something else. We'll close that and we'll look at the Evidence Act, Commonwealth. And in particular, Section 54. Before I do, I'll just mention this. Evidence is material. Material offered in a court proceeding during a trial to enable either the magistrate, if it's a magistrate's court, or jury, if it's a district court, or sometimes a judge, to reach a decision on disputes in issue. So we have this adversarial system of justice. What that means is that the court doesn't go about determining the facts for themselves. Instead, it proceeds to judgment based solely on the evidence presented to it by the parties. So the parties, that's the lawyers representing the litigants, need to understand the rules of evidence in order to present the evidence upon which the court makes its ultimate decision. When you're doing that, think about your case theory. Parties attempt to prove to the court that they have the more persuasive case, and you do that by developing a theory of the case. So when you're reading that statement by Xavier Kelly, whether you're defence or prosecution, you'll probably think of things that create a theory in your mind as to what happened. That might be your case theory. Okay, I mentioned the Evidence Act Commonwealth. Now, the fact is that we have two relevant pieces of evidence legislation in Queensland. That is the Queensland Evidence Act, which is 1977, and we have the Commonwealth Evidence Act, 1995. What I've got up on screen at the moment is part of the 1995 Commonwealth Evidence Act. Why do we have two pieces of legislation to do with evidence? Well, in simple terms, the State Act deals with state laws and state litigation. The Commonwealth deals with Commonwealth laws. And the Commonwealth Evidence Act is part of the uniform laws, which are adopted in many states, but not Queensland. The uniform laws are not a comprehensive code of evidence, but when they apply, they do replace the old common law rules that preceded them. It's not the case with the Queensland legislation. It's not a code in any sense. And our state law is based on common law, which is then subject to the terms of the Evidence Act 1977. All right, I hope that makes some sense. Okay, let's have a look at the Commonwealth Act. Now, why have I got it at Section 54? It's an odd place to look. Well, in the context of the first assessment, I think Section 54 is really useful. Well, more particularly the introductory note to the outline of the chapter is useful, because that part of the Act deals, albeit at a Commonwealth level, and we're dealing with Xavier Kelly at a state level, but at a Commonwealth level, many of the broad principles apply in the same way they do in the state level. So it's useful to look at the Commonwealth legislation to get an overview of how evidence law works. You'll see the statement at the top. This chapter is about evidence adduced in a proceeding that is admissible. What that tells you is, or whether evidence adduced is admissible. So what that tells you is that some evidence may be available, but it may not be admissible. So earlier today I said, have a look at chapters 9, 10, 11 of Field. They deal with issues to do with the inadmissible evidence, which is hearsay or opinion evidence, maybe even identification or corroboration. Hearsay might be relevant in the first assessment in the sense that you don't want, as a prosecutor, you don't want Xavier Kelly leading evidence which is clearly hearsay evidence. Hearsay evidence is evidence which is given by a witness as to what somebody else said or heard or saw. We don't want that. It's not admissible. And likewise, if you're cross-examining Xavier, you're not going to ask him about hearsay evidence because none of that's admissible. Likewise, opinion evidence. You'll see that essentially there are two types of opinion evidence which are admissible. The first is expert opinion, and that's the most common. And the second is non-expert or lay opinion. But in order for anyone to express an opinion, they need to establish that they have something special in their knowledge, not just simply observation, but something other than that, which, if you like, entitles them to provide their opinion. Let me backtrack, and I'm talking now in the context of the exclusion of opinion evidence on the basis that it's not admissible. If you ask Xavier Kelly this question as the prosecutor, do you think that Bancroft is guilty of robbery? That's clearly an inappropriate question because you're asking this witness to proffer an opinion. The law says we don't care what Xavier Kelly thinks. We don't care about his opinion as to whether or not Bancroft is guilty or not. That's irrelevant. So therefore it's inadmissible. But if you're asking a different witness in the same case about DNA analysis, and that witness is an expert trained in DNA analysis, then that's a different thing because then you're asking the witness for an opinion, but it is an expert opinion. But the category of non-expert or lay opinion is a bit different, and it's really where a witness is asking for some sort of statement as to various things, which include, for example, in the text it says, it's legitimate for a witness to be asked whether a victim looked frightened or the apparent age of someone they saw performing a particular act. That's okay. So it's still an opinion, but it's permissible. Okay, so just be careful about that. Let's go back to the Evidence Act Commonwealth. And that act talks about the general inclusion that relevant evidence is admissible and the general exclusion that hearsay evidence generally is not admissible. Generally, opinion evidence is not admissible. And it talks about other issues that may result in evidence being deemed inadmissible. Let's have a look at the flowchart. Now, this flowchart is in the Act. Sure, the provisions relate to the Commonwealth legislation, but the general rules apply at a state level. So what you're looking to do is ask yourself a series of questions to determine whether or not any particular evidence is admissible. Keep that in mind as you're preparing for your assessment. But do remember to apply the state law rather than the Commonwealth law in this case, of Xavier Kelly. I mention the Commonwealth law because it's got this handy flowchart. I'm just going to stop the share now for a second. So what you're looking to do is lead evidence that is relevant and admissible. And you need to ask yourself a series of questions. The first is this information relevant? Relevant to the charge, as I mentioned, is key. You're looking to adduce evidence which is relevant to the material facts in the case. Is it admissible? Even if it's relevant, is it admissible? Let's think of an example. Something that you might think is highly relevant but not admissible is evidence as to previous convictions. In our Queensland law, that's not something that can be put lawfully as part of a prosecution case. And as defence counsel, you would need to be very careful about asking questions of a witness as to their criminal history, because that might expose your client in different ways to the prosecutor then being able to attack his, in this case, his credit. So the information needs to be relevant, but it needs to be admissible as well. So what do we mean by relevant? It's not defined at common law. It's not in the Queensland legislation, but it is defined again in the Commonwealth Uniform Laws. So let's have a look at the Commonwealth laws because they're pretty close to the Queensland position at state level. And we'll share the screen and we'll go back to looking at section 55 of the Commonwealth Act, if you've got that handy. So what we want is section 55 of the Act. The evidence that is relevant in a proceeding is evidence that, if it were accepted, could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceeding. Well, let's break that down. I often look at these things at the end first. What we're trying to do is adduce something that will affect the probability of the existence of a fact in issue. A fact in issue is what I've been describing as a material fact. Who cares, in this case, whether there were clouds in the sky on the horizon? It doesn't matter. That's a fact, but it's not a fact in issue. A fact in issue is something that's important, that is in dispute between the parties. I'll just stop there. In reality, some facts you don't need to prove, even though they're material. And the reason is that you may have a material fact, but it's not in issue. What do I mean by that? Well, a fact that is material is something that goes towards proving the case. In issue means it's being challenged. It may be that defence don't challenge certain things, even though they are highly material to a particular case. Classic example is that of, say, rape, where the defence is there was consent. The essential elements of the rape are penetration without consent. If defence say, yes, there was penetration, that fact is not then an issue, is it? It still needs to be proved, and the way it's done in reality is that the lawyers will agree to that fact, and there'll be a concession to that effect at the start of a trial. The judge will then direct the jury that they can take it that there was the penetration, and all they really need to do then is think about the fact and issue, which is consent. So let's go back to that definition of what's relevant. What we need to do is determine whether there is a fact which is in issue in the proceeding. And evidence is something that is produced to a court, if it's accepted, could actually affect the assessment of probability of that fact. So we're looking for something that might change the view of a party. So that was the situation. Okay, I understand, says the juror, following on from the evidence which might be adduced in relation to a certain issue. When we talk about it being directly or indirectly, we're really talking about direct evidence in the sense of precisely what someone heard or saw or smelt or touched or said, as opposed to indirect, which is circumstantial. So direct evidence of a witness in a robbery might be, I was in a shop and I saw this defendant hold a gun to the person behind the counter and demanded payment, and I saw that with my own eyes. Indirect or circumstantial evidence might be, I was outside the shop and I saw someone run from the shop after I heard a loud noise and screaming. So that's circumstantial evidence. But it indirectly could rationally affect the assessment of probability of the existence of a fact, that is the fact of the robbery, in the proceedings. So evidence is not taken to be irrelevant, this is subsection 2, only because it relates to credibility of a witness, the admissibility of other evidence, or failure to adduce evidence. So think about that in the context of what you're trying to prove in this case. And I mentioned that what we don't want is a situation where people are producing evidence which is relevant but not particularly important. We want to try and avoid that situation if we can. And lawyers talk in terms of difference between bare evidence, which is relevant but really not that important, as opposed to relevance in the context of something that is material. All right, so when we're talking about relevant information, we might be talking about a whole range of different things, including convictions for identification, etc. Okay, so there is a discretionary power generally for courts to exclude evidence in circumstances where they are of the view, that is, the judge is of the view, that it would be unfair, prejudicial, misleading, maybe confusing to a witness to allow it to be introduced into evidence. So bear in mind that general exclusion discretion available to a judge, which at a Commonwealth level is section 135 of the Act. The other thing that you need to be careful of when you're preparing for this assessment is whether what you're adducing is relevant, but only mildly relevant in the sense that it goes to a collateral issue, not the primary issue. So I talked about the material facts, and there is a graduation in that regard. Something might be relevant, it might logically go to establish a fact in issue, the probability of that fact, but it may be only marginal. So we would call that bare evidence as opposed to highly persuasive evidence. Okay. All right, let's go on to look at admissibility. So there are 3 ways in which evidence might be inadmissible. One is that it might be unreliable. Hearsay or opinion evidence is unreliable evidence. You know, just because if you go into a witness box and say, well, I overheard somebody saying something, that's very unreliable evidence. So we say it's so unreliable, it should be excluded. The second basic ground upon which evidence might be excluded is that it has a tendency to mislead. In other words, the logical priority of probity is outweighed by the prejudicial effect. You hear that a lot with lawyers. We talk about probity, meaning its ability to prove something. And we often compare that with the prejudicial effect that it might have. So maybe the evidence of criminal history and the fact that Bancroft has committed 12 armed robberies over the last 10 years, that might be highly relevant, but it also might be so prejudicial that it is not, it is evidence that actually misleads. In other words, why bother having the trial? As soon as the jury hear that he's committed 12 armed robberies in the last 10 years, they're going to say, well, he's guilty. So that's where there's this set-off between probative evidence and prejudicial effect of the evidence. So our law says that that's something that the judge can take into account. All right. In terms of evidence, bear in mind also that there are some burdens. You'll hear about and read about burdens. We use that term in a few different ways. One is the burden of proof. Who has the onus of proving the matter? In criminal law, the burden of proof, the standard of proof, if you like, is to beyond reasonable doubt. In criminal law, it's on the balance of probabilities. But in your reading material, you would have read about the evidential burden and the legal burden. So the evidential burden in relation to a matter means the burden of adducing or pointing to evidence that suggests a reasonable possibility that the matter exists or does not exist. Okay. The legal burden means the burden of proving the existence of a matter. That's where the prosecution, in this case of Xavier Kelly, where Xavier Kelly's the witness, they must prove the existence of the matter beyond reasonable doubt. Sometimes the legal burden goes back on the defendant. When that does happen, the defendant has to discharge that burden on the balance of probabilities. So it's the same as the civil standard. So a burden of proof that a law imposes on a defendant is a legal burden only if the law expressly specifies the burden of proof in question is a legal burden on the defendant, or requires the defendant to prove the matter, or creates a presumption that the matter exists unless the defendant proves to the contrary. So I'll just backtrack. What I'm talking about now is who has to prove something in a case. In criminal law proceedings, essentially that's the prosecution, and the prosecution has to prove beyond reasonable doubt. But sometimes, in relation to the substantive issues in a matter or some evidentiary aspect of the issues in a matter, the law says, no, we'll get the defendant to prove this. And you'll read about that in various contexts. It's common in the sense that it crops up regularly, but it's not common in terms of being, it's not like 50-50 or anything like that in terms of reading sections. So overwhelmingly, the responsibility for proving something in a criminal matter is with the prosecutor. But there are also tactical burdens. Sometimes the defence will have to make a tactical decision. At the end of a Crown case, defence will be called upon by a judge as to whether they wish to give or call evidence or both. Giving evidence means the defendant going in the witness box and giving his or her evidence directly. Calling evidence means the defendant doesn't actually go in the witness box, but does call evidence to support the defence, or it can be both. So where the prosecution has reached a stage where their case is pretty strong, and unless the defence does something about it, there'll probably be a conviction, defence have the opportunity to present their side of the story if they like. So the right to silence in criminal law trials is paramount, and it stands throughout the whole period of time. But it is possible for defence to go in and seek to counter that evidence by providing evidence of their own. As you're reading the material, have a look at Weissensteiner against the Queen, 1993 Commonwealth Law Reports. In civil proceedings, it's a little different. The standard of proof is beyond reasonable doubt, but there must be enough evidence for the court to draw what we call a positive inference about their case theory, and they need to have produced that evidence to the requisite standard in order for that evidence to be accepted to win the case. So let's give an example of that. So we're talking about a civil matter, and we're talking about the need to actually produce enough evidence to get over the line. Have a look in the decision of Risa Shipping against Edmonds, 1985, 1 WLR, Weekly Law Report, 958. Look, in that case, a shipping company sued an insurance company. They sought compensation with respect to the loss of their ship. The ship sunk for no immediate reason or obvious reason in the middle of the Mediterranean. It was calm seas, and the evidence suggests that the ship had sprung a large hole just before it went down. So the shipping company's case was it struck a submerged submarine. That was their case theory. That's what it must have been. The insurance company's case was, well, the vessel has been badly maintained. At trial, the judge found in favour of the shipping company and said, look, your theory, although it's improbable, was less improbable than the insurance company's. That went on appeal, and the House of Lords overturned that judgment and said the judge is not obliged to accept either of them. If he found them both improbable, then so be it, because we must remember the ultimate burden of proof is borne by the shipping company, and it must do more than merely produce a theory that is less improbable than the other side's. It must produce a theory more likely than another theory and stand on its own merits. In other words, they have to adduce evidence so as to allow the court to draw a positive inference in favour of it. Have a look at section 140 of the Evidence Act in that regard. Now, I'm talking the Commonwealth Evidence Act here. I apologise that I'm concentrating mostly on the evidence Commonwealth situation at this stage, because this section brings into play a thing called Briginshaw, and I want you to understand that. All right, so you should be saying the Evidence Act, section 140, and note that in the civil proceedings, the party proving its case must do so on the balance of probabilities. And the court, when deciding this matter, must take into account the nature of the action, the nature of the subject matter, and, this is important, the gravity of the matters alleged. Why is that important? Well, what happens there is that the legislation is, in effect, incorporating the test explained in Briginshaw and Briginshaw. That was a 1938 decision of the High Court. It's 1938-60 CLR 336. What Briginshaw is all about is this. The court is entitled to demand more evidence of better quality in circumstances where the gravity of the matters alleged is greater. If you have a very small matter involving a small amount of money, then the court may well say, look, the evidence that you've produced is fine, I don't need any more than that. But if you're dealing with a very substantial matter, a ship, a liner going down in the Mediterranean, then you really need to take into account the whole of the circumstances and consider the gravity of the matters alleged in coming to a decision. All right, you're very patient bearing with me. I won't be much longer. When you're considering the question of reasonable doubt in the context of criminal law proceedings, have a look at a thing called the bench books. In particular, bench book number 57. For those of you not familiar with the bench books, there are a series of commentaries issued effectively for the benefit of judges They're publicly available. You can check them through the court's website. And you can look at what is, in essence, a simple script for a judge when addressing a jury in relation to certain legal issues. If you look at bench book number 57, it deals with the issue of reasonable doubt and says if the jury is struggling with a concept, the bench book provides the standard direction regarding reasonable doubt and says that it's up to the jury to determine on the evidence whether they believe it's reasonable, and if as reasonable people they have doubt about the guilt, then the charge hasn't been proved beyond reasonable doubt. Now that's paraphrasing it, but have a look at bench book number 57 and the other bench books and you'll get an idea of what the courts work on, if you like, as their script when talking to a jury. Now, many judges don't follow the bench book. Some choose various parts of the bench book. Others have their own way of describing things. But it's useful as a student to look at that. Look, I mentioned before that sometimes the legal burden changes and goes on defence. In that regard, a few examples. Section 26 of the Queensland Criminal Code deals with the issue of insanity, and there's a presumption of sanity. Every person is presumed to be of sound mind until the contrary is proved. So that's a presumption. The prosecution don't have to prove that the defendant was sane. We start with that. That's a legal presumption. But the defence can lead evidence to disprove that that's the case. So it's what we call a rebuttable presumption. Another one is Section 304A, diminished responsibility in relation to a charge of murder. Section 124 of the Drugs Misuse Act provides that there are legal burdens that are placed on the accused to prove facts, to establish their defence. And Section 129 also of that Act is relevant. So have a look at those things as well. Okay, well, I hope today's session's been useful for you. Look out for UCREW because we'll be discussing the first assessment in more detail over this next week. Please get your groupings together, contact me, and I'll update my notes with respect to those groupings. Now, all the best.